sure too much. It might be a little too much, but I don't care. It's fun. My name is Brooke Bove, and I am an appellate lawyer here in Southern California and legal writing enthusiast. I have spent the last 10 years writing briefs of every kind and shape and form that you could ever think of. And I'm here to talk today about a demur. In Southern California, it's called a demur. It's actually called a demur in all of California. In federal court, it's a motion to dismiss. I don't know what it is in your state, but basically it's a challenge to the complaint. If you're the defendant, you could bring a demur that says this complaint is not valid. Even if everything this complaint says is true, it's not enough to actually assert a cause of action against me, and therefore it has to be dismissed. There's no way plaintiff could ever, based on what's in this complaint, even if plaintiff could prove everything in this complaint, there's no way the plaintiff could ever win. That's what a demur is. I don't really know where the word demur comes from. This one attorney I worked for way before law school, I worked as a legal secretary, and he was trying to explain demur to me, and he was like, it's like when you are, like, the way you got your husband, you acted demur. And I was like, I don't know what you think happened in this relationship, but anyways. A demur is an objection to the complaint. And because it's an objection, it's not a motion. So don't tell the court you're making a motion for demur. Do not ask the court to grant your demur. As an objection, it can either be overruled or it can be sustained. If it's sustained, the court will either give the plaintiff leave to amend, give them a chance to fix the problems in the complaint, or they'll sustain it without leave to amend, which means the case is over. Okay. A demur tests the legal sufficiency of the pleadings, of the causes of action asserted by the plaintiff. There's a presumption in a demur that all of the factual assertions made by the plaintiff are true. We're going to presume that it's all true. And this is not an evidentiary thing you're bringing. So you cannot bring any evidence to this. You cannot submit declarations to support anything. You can't bring in evidence. You can't, no deposition testimony, nothing that the court would have to consider the evidentiary value of. We're looking at the complaint, and that's it. The exception to that is you can ask for the court to take judicial notice of things. And judicial notice is granted for things like a pleading from another court, or official documents somehow that are, filed somewhere, or like authenticated by an official public agency of some sort, something like that. So say you want to say the contract on which the plaintiff the plaintiff in their complaint is bringing this thing about like a breach of contract, for example. But in this other lawsuit, we already found out that this contract is not valid. And so the plaintiff can't bring this complaint because based on the rulings or the outcome of this other case, now we can bring that in as new information to the court. But because we're taking judicial notice of official court documents in another case, right? So I can't say, well, plaintiff's a liar because I have this evidence over here that says he's a liar. That's not going to be considered by the court. Only things that can be judicially noticed, and only the complaint itself. Now, let's talk about sufficiency of the pleadings. When you're bringing a complaint, obviously you have to assert enough facts that are going to meet the elements that you have to prove for that claim. If you're bringing a complaint for negligence, you have to assert that the defendant had a duty to do a thing, that they breached that duty, that the breach of that duty caused harm to plaintiff. You have to have facts that show those things in your complaint. And this is pretty easy to do for most causes of action. You just basically assert that there was negligence, that there was a breach of duty, that there was these minimal things that meet the elements of your claim. Some claims and causes of actions have heightened pleading standards. Things like fraud, you have to provide much more factual information to make a fraud claim. You have to, if you're asserting punitive damages, if you're asking for that in your prayer for relief, then you've got to have enough facts that would allow a court to say, yeah, this is a pretty egregious thing, and punitive damages are a potential outcome in this conflict. Almost always, the court will give leave to amend if it's feeling like, if it sustains the demur. Almost always, the court will give leave to amend, usually once, or for sure once, sometimes 2 or 3 times, if the plaintiff can show the court that, yes, it could be amended in such a way that it could fix whatever problem is wrong. Some problems can't be fixed, though. A statute of limitations problem, that's not going to be fixed. You can't change facts. You can't change dates. You can't lie. So if you say something, say you bring a complaint, and in the complaint, you make some factual assertions, and you say something like, this thing happened on January 1st. And then the defendant brings a demur and says, well, it could, if it happened on January 1st, now that the statute of limitations is run, and the plaintiff cannot win this claim. And so the complaint just has to be dismissed. So to make the complaint something that would be within the statute of limitations, you would have to lie or make a factual assertion that is completely different from the previous factual assertion you've made, which means one way or another you've lied in a pleading, and the court's not going to be happy with that, and they're going to dismiss the case. So if you're bringing a claim, make sure all the factual assertions are there. Bring as much detail as you possibly can. I know that sometimes you don't want to get mired down in detail, and things might come out in discovery that might make the complaint facts different, or might change the perception of them. So there's always the desire to kind of keep the complaint general, but be aware that the defendant is going to want to try to get things dismissed, and that you need to factually plead. You need to plead sufficient facts to actually support the cause of action you're bringing as a plaintiff. And if you're a defendant, there are lots and lots of ways to attack the pleading. So next video I do about this, we're going to go through the order of operations, and I'm going to use a real life example of a demur that I have opposed that as a plaintiff, and we'll kind of talk about the ways that the complaint was attacked and challenged, and how we got around it, or how the court dealt with it. So that's going to be the next video. And I don't know, maybe should I leave this shirt on? I don't know, maybe I'll change it. Anyways, have a great day. Make it a good day.